Oh, there we go. Good morning. This is Judge Alyssa Perez presiding over the 210th District Court Civil Docket for July 9th, 2025. All matters being heard today are being heard in accordance with all directives regarding remote proceedings. In addition to that, we are streaming all matters live via YouTube for public viewing. I'll go ahead and call our next case. It is cause number 2025 DCV 0542, France Pierre versus Claire Shamblin Caton. Sanel Van Wyck et al. May I have announcements, please? Mr. Pierre, if I could have your announcement.
Yes, my name is Franz Pierre.
Thank you, sir. And your attorneys appearing?
Morning, Your Honor. Rob Negrin. The last name is Negrin on behalf of McCarthy Holthus LLP.
All right, and we are set today on, I believe it's Mr. Pierre's motion. What is the title of your motion, Mr. Pierre?
My title of motion is there is a second amendment to the direction for rent collection in El Paso, ma'am. Is the second amendment.
When was that one filed?
That one was filed last week. I do not, let me see if I can give you an exact date, ma'am.
I'm showing July 2nd.
That was the second amendment. There was an first amendment that was filed a week or 2 weeks prior. The second amendment was filed last week. Yes, ma'am.
So you're asking to proceed on the second amended motion for court directions on tenant payments?
Yes, ma'am.
And that was filed on July 2nd?
Yes, ma'am.
Okay. All right. Counsel, did you receive a copy? I'm just wondering if people are getting served with these. Does everybody have this document? No? I'm seeing heads shaking no, but so obviously when the court scheduled this, Mr. Pierre, it was on, I don't know if even if it was the first amended, but it was since on our last hearing. I know you already had a live pleading because if memory serves, you were may have been asking to go forward at that time, but the court wanted to make sure we had ample time for parties to have received, reviewed, and been able to respond to your motion. Now we have a second amended motion. And so I need to say, Ms. Caton, are you appearing? How are you appearing today? I'm seeing your head shaking and not hearing anything else.
No, Your Honor, I'm here solely today on special appearance to challenge the court's personal jurisdiction over me.
Okay. Okay. All right. Mr. Negrin, did you get a copy of the second amended motion?
Sorry, Your Honor, I was muted. I received something, but I'm not exactly sure that it's the second amended.
Okay. Mr. Medina, are you showing that these are getting served on Mr. Negrin in the e-service?
Let me go ahead and check that for you, Judge.
All right. While he checks on that, Mr. Pierre, whenever you're ready, I'll go ahead and hear your argument on your second amended motion.
Your Honor, I do have a copy of the plaintiff's second amended motion for court directions on tenant payment and preservation of tenant rights.
All righty. Thank you very much. Mr. Pierre, you may proceed.
Yes, ma'am. Good morning. They're going to turn the music down a little bit. Ma'am, thank you for this opportunity to present this second amendment to the direction and guidance for the El Paso rent. At the crux of this issue, or at the crux of this case, is not to challenge Ms. Claire, is to challenge that the Virginia order has not been domesticated in Texas. I am not challenging who she is. I am not challenging what she does. I'm challenging the way she does some things. For example, as you may be aware, on the 21st of October of 2024, I had fired Miss Miss Aguilar. Therefore, she does not represent me from the 21st of October. That is on an exhibit, I believe is exhibit B in front of you. It will show that Miss Aguilar was fired. Now, there is a contract that was signed on the 23rd or the 24th. That's 2 days later, but I did not sign that contract. It was signed under duress. Since Miss Claire was appointed from Virginia as commissioner of sale, she has never domesticated her order in Texas. However, Mary has been taking directions from her. So Mary, since she got fired, she should not have been collecting the rent. However, Mary has been collecting the rent and held on escrow, and that has created great harm to myself and my property. Now, it is very clear that Mary was fired on the 21st. The question is, why is Mary continue to collect rent? There's an email that is attached. I believe it's K or L. I do not have it in front of me. It shows that Mary is in communication with lawyers in Virginia. That communication stipulate that she need both signatures in order to transfer the rent. However, Mary does not have my signature, and I do not believe she has Sanel's. Now, why does Mary continue to collect the rent and not stop collecting the rent since the time she was fired? Ma'am, she was under the impression that Miss Claire has all the authority from Virginia to dictate and direct where the rent goes. Now, I show you that the rent since then collected is about 11,000 plus the security deposit. Mary continues to collect the rent, and I believe she turned it over to Miss Claire. Now, there's an order, there's an attachment order that shows that Miss Claire, one, expressed to the court that she understood that she needs to domesticate the Virginia order in Texas. However, she has not. She also asked the court in Virginia to give her permission to take the rent from Texas, which she does not have Texas, she does not have Texas permission or a court in Texas because she has not domesticated the order. So Miss Claire is acting on a Virginia order directing action and activities in Texas. That is against the laws in Texas. Now, because Miss Claire believes or her action in Texas is legal, I am asking the court to say that the Virginia order, since it has not been domesticated in Texas, it should have no impact or effect on what happens in Texas until it is domesticated. Again, at the center of this case is one, the, the domestication of a foreign order that is required by Texas law to be domesticated in Texas in order for it to be executable. However, Ms. Claire has not done so, but she has been directing and in communication with Mary about what happens with the rent. I fired Mary. She should not be collecting the rent. She should not be representing me on the sale of the property in Texas. She's fired. I don't understand why she continued to believe that she has my authority to do any action on my behalf. And there's nothing on the record that says that Miss Mary has permission from Sanel, who's the other co-owner, to do anything on the property. So it is extremely harmful to my property rights in Texas that Miss Claire continues to direct what happens in Texas. She has not domesticated the order. So it is an illegal activity that she's performing with Mary and herself. So that is what I wanted to present to the court to show that Mary was fired, continued to collect rent, which is not authorized. She either hold on to the rent and passed it to Miss Claire because Miss Claire has stated that she wants to use that rent money that is collected in Texas by Mary, which doesn't have a Texas order, to use that money against me or to find a lawyer in Texas to go against me in terms of representing her in Texas. Even though she has not done so, the money is held, and I'm asking the court to, one, direct the tenant not to pay, not to give the money to Mary, and pay directly to the bank. It has an account. The money should be deposited there. The other issue is, since the rent has not been turned over to me, a big chunk of the reason that the house is in foreclosure in Texas is because they have not received payment. It's not the complete reason, but I would say 50% of that reason is because that rent has been collected and not been paid. I'm asking the court to have that money refunded and turned over to the bank. That's my presentation to you, ma'am.
Thank you, Mr. Pierre, and Ms. Caden, I'll hear you now on your special appearance.
Thank you, Your Honor. As you know, I was appointed Special Commissioner of Sale by the Fairfax County, Virginia Court. And I haven't taken one step in the state of Texas. I haven't even had a phone call about the El Paso property. I'm afraid Mr. Pierre is misinformed about how much communication or direction I have provided to anyone in Texas. I've been completely hamstrung in my obligations to the courts in Virginia by Mr. Pierre's continuous litigation. I couldn't sell the property. I haven't tried to sell the property because of the continuous lawsuits. No settlement company would touch it. I've had no communication with the tenants. I have never tried to evict the tenants. I have not collected one dime of rent. And Ms. Aguilar was following the Virginia court orders, which she was provided by Ms. Sinell's attorney. I had nothing to do with telling her what to do, but none of those rents rely on me. Mr. Pierre hasn't sufficiently alleged minimum contacts with Texas, which would give this court personal jurisdiction over me. Perhaps in the future, if I were to continue or be able to continue my role as Commissioner of Sale, that would be a different story. But as of now, I haven't been able to do anything in Texas.
Ma'am, I object to her statements on the ground that we are not hearing her motion on this issue today. The issue at hand is my motion to redirect the rent. I have filed an opposition to Ms. Claire's statements. I believe that should be here at another time, but if you choose to hear it today, there's an email
File it,
on,
Mr. Pierre?
say again, ma'am?
When did you file your opposition?
I filed an amended opposition to Ms. Claire. Are we hearing her conversation, her motion today?
Asking to find out because I do not see one in the pleadings when you filed it.
I did file an opposition. Let me give you the exact date, ma'am. Okay, ma'am, there is envelope number that ends in 1382, and it was filed on June 25th. And it was, it was filed on 24th June. On 25th June, it was accepted. And I believe there is an amended opposition that shows the different level of contacts that Ms. Claire, who stated that she doesn't have any contact in Texas, it clearly showed that she was in contact with the uh, MacArthur and Holsis, because it was on her behalf that they took the home off foreclosure. The other reason that it's clear that she's had contact in Texas is that she described a conversation in our last hearing. She was not a party to that hearing. However, she's fully aware of what took place. For example, it was Mr. Bertrand who asked me for my residency. However, Ms. Claire stated that in her
Mr. Pierre,
petition.
you're doing two things. You're telling me not to consider it, and then I'm understanding that you're arguing now on it. So in terms of the special appearance, and I am seeing now your opposition and motion to strike, the court is going to consider those via submission. You will have a response by the end of this week.
Yes, ma'am. Thank you so much.
Thank you very much.
So,
Thank you, Ms. Caton. If you don't have anything else, you're welcome to stay. But the court will be considering the request and Mr. Pierre's response via submission. I'll have a ruling by the end of the week.
Your Honor, would you require Mr. Franz to send me a copy? I did not receive a copy of his opposition.
So yes, we can, and I gotta assume you're not served because you're not on the e-contacts on the e-serve.
ma'am,
Probably not, but
she was on the
Mr. Pierre knows
e-console.
how to contact me.
Okay, so Mr. Pierre, you are do you have an email, or what is it that you have?
He has my email address, Your Honor.
Mr. Pierre, you're going to be required to serve Ms. Caton with your live pleading the opposition to her special appearance and your motion to strike.
Ma'am, can I have permission to send it by email because she has a PO box number?
Yes,
Her mail
that's fine.
by email,
Yes.
and I will provide the court that I actually sent it. I cannot confirm whether she received it or not because I don't have that. She's been part of this case since the beginning of me filing this, and she's been the clerk can shows that all the people that are served. But however, I will submit an email to Ms. Claire about my opposition.
Okay, anything else on your motion for court? Is it instruction? Anything else on that, Mr. Pierre?
Yes, ma'am. It's extremely important to rule in my favor because the money that has been collected needs to go to US Bank. That is 11,000 plus. The other thing to clear with the court is that the Virginia order has not been domesticated in Texas. For actions against any executable actions in Texas should be illegal. And I do require that the money that was collected, I showed you the receipt that it was sent from from Adriana to Mary. In addition, there's a document that shows that Claire is using that money or trying to use that money to file to use a legal system against me. It's important that the money return. It's important that the court state that her action in Texas has been illegal and it's all based on Texas law. And it's also important that there are damages to me that I actually laid out on what those damages are in terms of my credit in terms of the opportunity that I've lost. Um, um, I forgot all the other damages that I've put, but they are on the document, and I would ask that the court consider those damages based on the action that Mary has done, either on behalf of Miss Claire or not. But she's actually held on to the rent money that should be going towards securing my mortgage and stop the default of my property in Texas, man.
Anything else?
No, ma'am.
Thank you very much. Mr. Pierre, the court is not in agreement with either the basis and or the relief that you are seeking. And so I'm going to decline respectfully to provide any direction and deny your motion. So we can generate, Jasmine will generate an order denying same. All pending motions, so the special appearance, the court will consider via submission. Mr. Negrin's motion to dismiss, which was filed today, will be heard in 1 week. If you are going to have a response, Mr. Pierre, please file it as soon as you can, as soon as practicable before that hearing. It may seem a little rushed, but the court anticipates being out of pocket for about almost a month on a trial. And so I want to make sure we address these things before scheduling becomes more difficult. So in terms of the scheduling status conference, I'm going to hold off on that. That's typically something that we would utilize to set future hearings. But in light of the motions that I think we're going to hear next week, we may or may not need it. So we'll set Mr. Negrin's motion to dismiss for Wednesday. We'll do 9 a.m. Mountain Time. Same thing on Zoom. And I will have a ruling for you on the special appearance and the motion, the response by the end of the week, okay?
Yes, ma'am. When should I expect the order of, I believe you said it's dismissed, or you do not have an opinion on that?
On your motion that we heard today, it's denied.
It's denied. Okay, ma'am.
Correct. So I'll get an order out as soon as I can.
Thank you, ma'am.
Let me see. Anything else for today?
No, ma'am.
All right.
No, thank you, Your Honor.
Thank you very much. Jasmine, if we'll just get this one scheduled for a motion hearing on Wednesday at 9 a.m., please. Thank you very much. Thank you for your time. You all are excused.
Thank you, ma'am.
Who's in the...
Ryan McCafee, Judge.
He's on something.
McCafee.
Well, I'll step away so we can start bringing folks in.
Yes, ma'am. I'll get him, try and get him squared away. Oh, good morning, Mr. Kathy.
Good morning. How are you?
What's the last for your cause number?
I'm here on the Cabral case. I believe it's 0886.
Great, thank you.
Good morning, Mr. Bailiff.
Good morning, sir.
You're gonna get on? Observe, good. Tell Richie if he wants to as well. How are you doing this morning?
I'm doing well. I was going to mention to you all right now before the judge comes on, if you plan to use any AV, I would highly recommend you come to the court and try your stuff out with us beforehand and make sure it's compatible. I would recommend that everything be put on a flash drive and then use our laptop rather than just try and plug it in your laptop, because then we can't guarantee how things will turn out. So
Okay,
anything presentations you're going to put up on the screen and stuff like that, I would try them out ahead of time.
all right, we'll do that. Do you know how long the judge has budgeted for this trial?
Substantial time. I'm not exactly sure how much, but it's substantial.
All month, Mr. Rincon.
Judge, greetings. How are you
month.
doing?
July, and from the one of the last hearings, I think you said August. I said, oh my, okay. You're it. Tags, you guys are it.
Hey, and if we end early, there's got to be a cone of silence. I'm still in trial, even though I might be in Laguna.
Hey, I don't disagree with that. I don't disagree with that. I'm trying. Well, I won't say. We'll leave it at that. Let me know when we're ready, Mr. Nunez.
I'm seeing, are we waiting for anybody else on for Mr. Rincon's case?
Let me see here. I can tell you if the looks
Well,
like people are there.
I have co-counsel that'll be appearing. Let me message them and make sure that they're coming.
Okay.
Good morning, Mr. Villanueva.
Hey, good morning, Carlos. How are you doing?
Great to see you, man.
Miss Guido, are you there?
Yes.
I'm here. Yes.
Are you here on the Cabral case?
Yes.
Okay. Thank
I
you.
might have Richie Cáceres and Donovan Ortega just observing. Donovan's a soon-to-be lawyer at our firm, and Richie Cáceres is our paralegal on the case as well.
How about Jameson Joyce?
I'm not familiar with them.
Hello, Mr. Joyce, are you there?
Yes, this is James and Joyce. I'm here.
Hi. What's cause number you here for?
I am here for, excuse me, 2023 DC V 3768.
Thank you, sir. Hello, Mr. Harris, are you there?
Yes, sir.
What cause number are you here for?
I'm showing up for 2024-2625. I believe we verified that we got the agreed judgment filed with you finally. But I wanted to make sure and appear and make sure since there was a hearing notice.
Thank you, sir. Hello, Mr. Nunez. What cause are you here for?
Overall case, PRV share.
Cabral case? Okay, thank you.
Yes.
Mr. Farrow, are you there?
Yes, can you hear me?
Yes. What's the last 4 your cause number?
One second. ECB 3617, Sonia Archuleta Munoz.
3617. Thank you. Mr. Rincon, Mr. Villano, are you expecting anybody else? Or are we good?
I think we're good to start. Mr. Brian Cathy is here, I believe. Yes, he's here. So we're ready to begin.
Okay, the judge will be on shortly.
Thank you.
Mr. Nunez, on the docket, I'm showing
Yes,
the
ma'am.
Cabral case at 2 separate times. Is that right?
In the Cabral case? Yes, ma'am. I've got it on page 2 and on page 8.
Okay. So we really like you all, so we would just want you here all morning. But maybe I'll ask. I think yours will take a minute and maybe we can, or maybe not. I have a motion to compel that is set at 11:30 and then the final civil pretrial. I'd like to clear up the screen since I see we have quite a few scheduling conferences, things that we can just knock out quickly, Mr. Nunez. Are you seeing any of those ready? If not, we'll just go into Cabral and let everybody.
No, ma'am. I've got on page 1,
Mhm.
the France cases. On second, on 3124, it's been entered. We've got an agreed judgment already entered. The
Okay.
expunction, I believe, is not going. So that
Okay.
takes care of page 1, and that leaves us free to go to this one.
Okay, well then let's just go. Is everybody ready on Cabral? You don't want to have the motion to compel wait till 11:30, right? We can just get going.
Yes, sir.
Okay.
Yes, Your Honor, and I think also it's a motion to compel and a motion to exclude Dr. Greenston.
Okay.
Those are the two motions, and we've sent you the motions, and I believe Mr. Cathy sent you their responses via email.
All right, give me 1 second. Yeah, I'm not seeing those in the email, but certainly I can get this. All right, Vince. All right, let's go ahead and call them. This is 2022 DCV 0886 Eduardo Cabral et al. versus RV Share LLC et al. May I have announcements, please?
Yes, Your Honor. It's Brendan Villanueva with Lyles White, and I'm also with co-counsel. We have Russell Post, Nicholas Bruno, and Anson Fung with Beck Redden.
Your Honor, Carlos Rincon, Rincon Law Group, and Brian Cathy, Right Close Barger here for Landstar. And I have Roberta Guido, Richie Cáceres, and Donovan Ortega just observing from Rincon Law Group.
Good morning, gentlemen. And so we were scheduled on a couple of matters today. I had reflected on the docket a motion to compel, but Mr. Villanueva, there was also you mentioned, and I'm a little behind here in trying to find the I guess objection to an expert. Is that what it is?
Yes, Your Honor. We filed the notice of hearing on 6/25, and the motion to compel was the first motion that was listed, and then the motion to exclude was the second.
What
So
date was that one filed, the motion to exclude?
the motion to exclude, that's an
July
older
2nd.
file. Yes,
Okay.
it was filed in October. I can get you the specific date.
Your Honor, it looks like it was filed October 2nd of 2024.
Got it. What I have here is the response, I think. Yes, okay, there's the response. The response was on July 2nd. Mr. Villanueva, let's start with that October motion.
And Your Honor, my co-counsel with Beck Redden will be handling that motion, so I'll turn it over to them.
Your Honor, Nick Bruno from Beck Redden on behalf of the plaintiffs. I'll be arguing this motion as styled as a motion to exclude the opinions of Dr. Greenston, as well as to exclude seatbelt evidence. Before I jump into Dr. Greenston, I want to be upfront with the court that we are not seeking a ruling on seatbelt evidence today. We have, as Your Honor is aware, we have another pretrial conference set for next week. And the ruling that Your Honor makes today regarding Dr. Greenston will inform the scope of the ruling that we need from the court regarding seatbelts. So before I go into Dr. Greenston's testimony, though, I do want to talk about seatbelts just to put Dr. Greenston's testimony into context. And we've previewed a little bit of this with our response to RV shared summary judgment motion that you heard last month. The particular issue that we previewed was that regarded the passengers in the back of the RV. For the passengers in the back of the RV, there is no legal requirement that they wear seatbelts. And we detailed this evidence into that summary judgment briefing, that the investigating police officer testified that seatbelts are not required for passengers in the passenger cab. He said because no seatbelts or child restraints were required, he did not issue citations for anyone in the passenger cab who was not wearing seatbelts at the time of this crash. The Texas Transportation Code confirms the investigating officer's testimony. For passenger vehicles, which is a statutorily defined term, passengers must wear seatbelts. But RVs do not fall under the definition of passenger vehicles under the Texas Transportation Code. Further, and I know there's going to be a dispute about this, and my friends on the defendant's side will say there's evidence that there were seatbelts in the back. There's also evidence there were not even seatbelts available to some of the passengers in the passenger cab of the RV. So that's the context of seatbelt evidence in this case. So where does Dr. Greenston fit into that context? Well, Dr. Greenston opines that certain plaintiffs' injuries would have been less severe had the passengers in the passenger cab worn seatbelts at the time of impact. His opinion is based upon a computer simulation where, and we'll get into that in a bit of detail, he uses this to opine about the way that he believes that the passengers in the back of the RV moved at the time of impact. Based on the movement that this simulation projects, Dr. Greenston extrapolates that injuries that certain plaintiffs suffered would have been less severe had the occupants been restrained by seatbelts. Now, I'm giving a very charitable spin on Dr. Greenston's testimony. He doesn't, for the most part, testify that specific injuries will not have occurred. There's a couple exceptions, but for the most part, his testimony is that injuries, quote, would have been diminished, whatever that means, had the occupants been wearing seatbelts. We'll get into that in a minute in the argument section, but for now, I want to highlight the key fact, which is that each of Dr. Greenston's opinions turns on the reliability of this computer simulation and its prediction about the way that the plaintiffs moved upon impact. What's notable is despite his report, in his opinion, being so primarily based and dependent upon the simulation, when it came time to defend this simulation, he distanced himself from it. As we just talked about, this motion was filed back in October of 2024. Dr. Greenston has had plenty of notice about the criticisms that we have regarding his simulation. You would think that the response that he filed earlier this week in his affidavit would have come to the defense of this simulation. It did not. Instead, in paragraph 12 of his affidavit, Dr. Greenston distances himself from the simulation, saying this quote, and I quote, "The simulation, it's explained in my report, models the occupant's motion vectors and is not an animated recreation of the accident event." That dooms this Dr. Greenston's opinions from a reliability standpoint. So our objection is based on reliability. When we're going through the analysis, I want the court to think about two particular Supreme Court cases that provide the analysis that the court needs to exclude Dr. Greenston's testimony. The first is the Gamble decision from the Texas Supreme Court in 1998 that we cite in our briefing. That opinion stands for the proposition that reliability analysis requires an expert to show that what, quote, he believes could have happened actually did happen, end quote. In other words, courts cannot admit expert evidence which is connected to existing data, quote, only by the ipsy-dixy of the expert. And I want to point out the facts of Gamble. So those are particularly analogous to the facts that we have in this case. In Gamble, the expert testified that various physical evidence, the shirt, various marks on the plaintiff's body, etc., showed that that were consistent with the plaintiff wearing a seatbelt. But the Supreme Court said that opinion clearly showed how the plaintiff could have been wearing a seatbelt, but the expert did nothing other than his say-so to connect what could have happened to what actually did happen. He didn't rule out other causes. He didn't say that these marks definitively show that the plaintiff was wearing a seatbelt. So that's one decision I want the court to keep in mind. That'll be important as we go through the analysis. Second decision is the Burrow Welcome v. Cry decision from the Texas Supreme Court in 1995. And that opinion establishes that, quote, when an expert's opinion is based upon assumed facts that vary materially from the actual undisputed facts, the opinion is without probative value. And in conjunction with that, there's an intermediate court decision, the Castillo v. Ford decision from San Antonio that we cite in our briefing that is on point with the issues that are being presented to the court today. In that case, there was a test done, what was called a SLED test, where the expert analyzed what would or would not have happened with regards to seatbelts on a particular truck. The problem was that in the truck, in the simulation, in the test, the, quote, glass in the rear hatchback window had been removed. Whereas the vehicle at issue in the accident in Castillo had the back glass. And the court said without having a simulation that mirrored a vehicle without glass, that opinion varied from the material facts and had to be excluded on reliability grounds. So that brings us to Dr. Greenston's testimony. Your Honor, can I share my screen? Because there's a couple slides I want to show you, which I think will help clarify.
You may.
Thank you. So the first issue we had with Dr. Greenston's opinion is that the simulation did not reflect the RV because it did not account for the seats and internal components of the RV. Think as welcome, think the undisputed facts. Dr. Greenston's report includes this simulation of the actual RV, which as you can see has, or excuse me, this graphic of the actual RV, which as you can see has a TV, has couches, has beds, has various appliances and the like. The numbers on this graph indicate where the various plaintiffs were sitting in the passenger cab of the RV. So this is the actual conclusive facts. This is the actual RV at issue. Lots of various equipment throughout. But when Dr. Greenston runs his simulation that forms the basis of his opinion, this is what he does. He has an empty RV cab. There's no furniture. There's no appliances. There's no TV. There's nothing, just an empty box. So we have a situation where Dr. Greenston's opinion, the basis of his opinion, the simulation, varies materially from the actual facts. The first graph shows where the parties, he says, plaintiffs were sitting at the time of impact or before the time of impact. Second figure shows the way they would have moved as a result of the impact. Well, he doesn't account for the actual configuration of this RV. He doesn't try to defend that. That, we think, is an independent reason to exclude Dr. Greenston's testimony because his simulation maybe showed what could have happened in an RV with nothing in it. It doesn't reflect the actual RV at issue. He simply did not do the work tailored to the facts of this particular case. The second issue that we have with Dr. Greenston's testimony relates to debris in the vehicle. I'm going to show you a picture, and this is the last slide I'm going to show the court. This is a picture of the inside of the RV after the crash. So you can see debris all over the place, a sink, various cabinets, bedding, boxes, etc. All sorts of debris. Again, this is the actual undisputed evidence of the state of the RV at the time or after the time of the crash. There was debris all over the place. Dr. Greenston's model, as you saw, assumes an empty RV. When he talks about the plaintiff's injuries, he assumes that these injuries were caused by the plaintiffs bumping into each other. He doesn't talk about the debris at all in his report. So again, Dr. Greenston's had this criticism since last October. It's now July. You would think his affidavit would address this debris. Does he? He says, quote, "There's no testimony identifying that the claimed injuries were caused by debris flying around inside the RV." To which we respond, look at the picture. There's surely debris in this RV. That's the last slide I was going to show, Your Honor, so I'll stop sharing my screen. But it's not just the picture. It's almost every witness in this case. The trooper who investigated this accident, Trooper Sandoval, in his deposition, page 30, said when he walked into the RV, quote, "The door was open and all the furniture that was in there was on the floor and misplaced." One of the passengers, Leo Gallegos Bonilla, testified that I had all sorts of things on top of it. A cabinet, a TV, a sink that were over me. Everything was pretty much all over the place. There was probably not one thing that was intact. He goes later when asked specifically about seatbelts, said, with all the debris falling all over the place, I wouldn't think the seatbelt would do anything. I mean, the seatbelt wasn't going to protect me from all the debris falling all over my head and my body. Another passenger, Christian Pacheco, testified, page 86 of his deposition. There was a lot of debris. I was trying to get up. I was struggling to get up, but my feet was stuck. Page 2025, he said, what affected us was the debris started falling. Things that were in the RV. Another passenger, Christian Manuel Ambrose, was asked, do you think there may be objects that came loose that hit your head? Said, yes, there were pieces of the RV. Asked, you're talking about cabinets, tables, things of that nature. Yes. Another passenger, Denise Gallegos, on page 116 of her deposition, testified, the RV was completely destroyed on the inside. There was nothing left. There were cabinets there. There was a lot of things everywhere. Page 182 of her deposition. There was a lot of stuff on top of me. I can't tell you what it was, but the RV didn't look like when I walked in there. There was nothing left. In sum, the conclusive facts in this case are debris was falling all over the place in this RV. You saw the picture. Dr. Greenston simply ignores this debris. He runs his computer simulation pretending this debris didn't exist. He gives his opinions about injuries the plaintiffs would have suffered had they been secured in place by a seatbelt, but he doesn't account for this flying debris and the injuries they would have incurred from this flying debris at all. His answer in his affidavit, there's no evidence of debris. You saw the picture, you heard the testimony. That opinion simply varies from the material fact, just undisputed facts. It has to be excluded on reliability grounds. The last point that I want to make regarding Dr. Greenston relates to his failure to do a comparison. Recall the graphics I showed you were basically those balls that he showed the way that he believes they moved as a result of this crash. He doesn't run a comparison simulation or give comparison analysis to show what would have happened had those passengers been wearing seatbelts. Again, we pointed out in our motion, he doesn't talk about whether his opinions based upon seatbelts that were actually available in the RV. He does not talk about whether he's relying upon 3-point seatbelts or simply lap belts or other sorts of restraints. He simply assumes that because these people moved in the way his computer simulation, removing everything from the RV and all the other issues we talked about, said that they moved, that they would have had diminished injuries. Again, whatever that means. That is exactly what the issue was in GAM. The computer simulation may have showed what could have happened in an empty RV, but there's nothing besides Dr. Greenston's ipsy-dixit to link his theoretical model, flawed as it was, to these particular plaintiff's injuries, especially in light of the debris and the like that was flying around that cabin. This is a paradigmatic example of an unreliable expert witness that just simply did not do the work that was tethered to the facts of this particular case, this particular argument. It's this kind of sloppy work that needs to be excluded on liability grounds.
Thank you, sir. Mr. Rincon, are you responding or is it Mr. Casey?
Your Honor, Brian Casey will be handling the responses today.
Yes, Your Honor. So just to start out to provide kind of a 50,000-foot overview, I mean, I think honestly it makes a lot more sense for the court to take up these expert challenges in the context of trial where you can better evaluate the testimony. Dr. Greenston's available to testify either today or at trial to clarify any questions the court may have. Although I don't really think you need to get there. I think you can look at the motion and deny it outright today. And, you know, I will weary of the court's time, but I will briefly respond to each of the points that were raised by opposing counsel, starting with the law on seatbelt use. The question in this case is not whether they violated some statute by not wearing a seatbelt. The question is whether they were negligent. You know, there's no law prohibiting you from eating a steak dinner while you're driving down the road, but that's still negligent not to do that. And so in this context, it's clear that the failure to wear seatbelts equates to negligence. And the Supreme Court in Neighbors versus Romero in 2015 explicitly held that evidence of seatbelt non-use is relevant and admissible. They overruled all of the prior Texas case law that was to the contrary. And so it's quite surprising that the plaintiffs point the court to several Supreme Court cases, but they ignore the controlling one that was decided 2 decades afterwards that clearly articulates the admissibility of this testimony. So when you actually turn to Dr. Greenston's report, I think the first thing you need to recognize is the gentleman's qualifications. They kind of briefly attacked it in their motion, but here, you know, they've entirely abandoned it, and that makes eminent sense because he's a medical doctor who separately holds advanced degrees in biomechanical engineering. He has extensive consulting in the area of injury causation. He's presented at events on this. He's even published articles on it. And so then the question becomes, did he have a reliable foundation and a reliable methodology for his opinions in this case? And clearly he did. The bulk of the plaintiff's motion actually focused on the lack of reliable foundation. One of the critical defining features of the plaintiff's criticism was they said, well, Dr. Greenston never even inspected the RV to know if there were seatbelts present. But today we hear opposing counsel say, well, there's a disputed fact as to that. And the reason is because in his affidavit, Dr. Greenston makes clear that he actually did inspect the RV in question, and he examined an exemplar RV, both of which had seatbelts in them. And so they've now abandoned that criticism of him because they refused to even take the gentleman's deposition. We provided deposition dates for plaintiff's counsel to depose him, but they've willfully, sidestepped that opportunity and now are attacking him on baseless grounds that clearly are, easily refuted. So, when you actually look at the materials that he did review, which we've outlined in his 23-page affidavit and in our 20-plus page response, he reviewed literally thousands of pages of photographs, deposition testimony, and medical records for each of these claimants. He also reviewed at least 50 separate published articles addressing the specific injury causation analysis in this case. So he clearly has a reliable foundation for his opinions. Similarly, his methodology that he employed, he runs through in his affidavit, talking about the scientific method that he used, explained why it has a low or no margin of error, how it's subject to peer review, it's accepted by the relative scientific community, and how his entire analysis develops out of non-litigation context. So clearly he meets each of the factors the Supreme Court has identified as relevant or as a reliable basis for expert testimony. Today, the two criticisms that the plaintiffs lodge is, one, they criticize his quote unquote simulation. He didn't undertake a computer generated simulation of this accident. What he did was model the force vectors for the movement and the forces that were exerted on the individuals in the RV. And so what he's doing is he's using the laws of physics to animate the potential forces that were acted upon these people so that he could therefore take subsequent steps and analyze their potential injuries and the effect of seatbelt on them. And so the notion that somehow that's insufficient or doesn't account for the specific layout of the RV is immaterial. He was attempting to do one thing and the plaintiffs are criticizing him for something else. And then the second criticism that's been lodged is that he didn't account for flying debris. But as Dr. Greenston outlines in his affidavit in paragraph 10, he was fully aware and considered the photographs, the deposition testimony with regard to the debris in the vehicle. The reason it's not in his simulations is, one, the simulation wasn't a simulation. It was just a modeling of the physical forces acted upon them. But separately, that was not the causal mechanism. The mechanism of injury is not somebody getting bumped on the head by a piece of debris. It's the relative changes in velocity upon the body as a result of the collision. And that's what his modeling was focused on. And so, today, the plaintiffs point out to certain, lay testimony that there was debris flying around, but lay testimony doesn't establish injury causation. Those witnesses didn't say they were injured by the flying debris. And even if they did, that's not competent testimony to refute Dr. Greenston's analysis that wasn't the mechanism of injury in this particular case. And I think all of this goes back to the point that, the plaintiffs are kind of grasping at straws and saying his opinions are vague and he doesn't address, the debris sufficiently in depth. But again, the plaintiffs could have explored all of these issues before moving to strike him in his deposition, but they didn't. And so I think when you look at the extensive affidavit that Dr. Greenston prepared for the court, it amply addresses and refutes all of the minor criticisms that have been lodged against him in this case. And I understand that the plaintiffs today have abandoned their claim to exclude all seatbelt evidence. But in their motion, that is the requested relief, was the exclusion of all issues of seatbelts. But the jury, under the Supreme Court's decision in Neighbors versus Romero, must be allowed to consider that issue. And so then the question is just whether the court's going to allow a highly qualified expert to explain the laws of physics and biomechanics to the jury, or whether the court's going to allow the lay jurors just to speculate as to injury causation without the support of any expert. I mean, obviously, the first path is the appropriate one. And the plaintiffs also in their motion attack Dr. Greenston's opinions as somehow being prejudicial, but all he does is address the laws of physics and applies them to this particular accident, relying upon his years of experience, including his medical degree. And so there's nothing prejudicial about it. He's not, attacking these individuals or calling them names or offering any kind of, improper opinions that would warrant exclusion in this case. And so for all those reasons, Your Honor, we'd respectfully ask that the court deny the motion to strike Dr. Greenston, or at least continue the case until the time of trial when the court can, inquire of Dr. Greenston as may be appropriate.
Thank you, Mr. Casey.
Your Honor, I'm sorry.
Go ahead.
A brief reply. You heard a lot of discussion about Dr. Greenston's testimony and his qualifications, which I think may establish what could have happened, to use the words of Gamble. If Dr. Greenston was being offered for purposes of some sort of medical explanation for generally how these sorts of injury or how these sorts of computer simulations or the laws of physics work, you just heard an excellent argument as to why he would be a qualified speaker for that purpose. What you didn't hear is why Dr. Greenston is qualified or provides a reliable opinion in this particular case. You heard what I thought was quite remarkable, an argument that injuries are not caused by flying debris. You just heard the witness of several of the passengers who testified that they were hit by flying debris. You saw the picture. Clearly, there was debris flying around in the RV. What Gamble requires is that Dr. Greenston connect his theoretical opinions about the theories of the laws of physics to the particular facts of this case. If he's going to say that injuries were diminished or would have been diminished had seatbelts been worn, he needs to prove that point. It's not our burden to take his deposition. It's not our burden to develop the defendant's testimony for them. It's their burden to show reliability. And that they did not do. Every criticism we lodged against Dr. Greenston's reliability cannot be met. One last thing I want to make, just to be clear. We did not abandon what I understood defense counsel to say, the argument that seatbelt evidence should be excluded. What's needed is a ruling on Dr. Greenston so we can know the scope, if any, of a ruling that we're going to need Your Honor to make regarding the proper scope of seatbelt evidence. So that issue is going to be ripe once we have a ruling on Dr. Greenston. We didn't abandon anything. Last point I want to make, and I want you to keep this in mind when we talk about seatbelt evidence, was what defense counsel opened their presentation with. There was nothing unlawful about the plaintiffs, the passengers, not wearing seatbelts. That this comes down to question of relevance, where seatbelts have actually reduced their injuries. Dr. Greenston did not provide testimony that's applicable to this case. He did not do the hard work to develop an opinion that's reliable in this case. He should be excluded for those reasons.
All right. Okay. All right. I can tell you absolutely certain that I am not ruling on this today. I do have to do my homework and my review. But what I will do is certainly have a decision before our next hearing, which is Wednesday. My goal is to have it by no later than Monday. All right. Okay. So then we have, in addition to that, a motion to compel. And again, I apologize. I'm trying to keep some of these things in order. The motion to compel, what was the date that was filed?
Let me get that, Your Honor.
I believe it was June 5th, Your Honor.
June 5th, yes.
Bear with me. There it is. All right. And Mr. Villanueva, are you handling the motion to compel?
Yes, Your Honor, if I may. All right, Your Honor, we're here talking about some interrogatories and request productions that we sent for Landstar. And I know we're a little late in the game, but this is really kind of repetitive of other discovery that should have been answered. So what I'd like to do is we can take this in a linear fashion. So it's Eduardo Cabral's request for production and interrogatories to Landstar. So if you don't mind, Your Honor, I'll share the screen so we can look at the specific requests.
Go right ahead.
Thank you, Your Honor. So really, request for production 1, it states produce all internal documents and communications, including letters, emails, text messages, and board meeting minutes discussing Landstar's potential liability for motor carriers hauling Landstar loads that are not operating under Landstar's DOT authority. And then 2 is similar. It's basically the same request, but with a little bit of different here at the end. It says discussing Landstar's potential liability for accepting loads as a motor carrier and then brokering out those loads. And then number 3, same question, but then potential liability as a statutory employer of motor carriers not operating under Landstar's DOT. So the reason this is important, Your Honor, is because this is the central factor in this case. Landstar says they were not the motor carrier for the shipment. We contend that they are. There's going to be a bunch of evidence, especially the evidence of the people that hired Landstar, that they hired them as a motor carrier and that Landstar accepted it as the motor carrier. Now, there's got to be discussions whether Landstar knows that potentially accepting a load as a motor carrier and then brokering it off could expose them to liability. I'll give you an example, Your Honor, right here from this case, which is exactly what happened. In this case, Expeditors hired Landstar to deliver a load, but My Universe did the physical transportation. So while Landstar claims it has no liability in this case, here's a deposition testimony from Landstar's agent. And I asked her, why did you get involved in the case? And she goes, because I needed to report this to cargo loss. And she goes, cargo loss prevention department? And I say, okay, is that a Landstar department? Yes, that is part of Landstar. Then I asked, so your understanding is that Landstar's cargo loss department would take care if there was any damage? Yes, they will take care. For example, if a toll bill has been paid, they pay it. If they need to like look for insurance or anything related to the parties, I mean, that's part of their job, not mine. She goes on to state in this, okay, what is Mr. Gordillo updating us on this email? He is trying to obtain information more from corporate to give an update. And that would be corporate Landstar, right? That would be corporate Landstar. So here's 2 things. First, I want to point out. These would be internal discussions regarding whether Landstar would be liable for loads that they brokered when they accepted him as a motor carrier. All right. So these are the types of discussions, emails, communications, things like that. But what I also want to point out to you is that Landstar has never produced any of these emails. You just saw where she's reaching out. I need to reach out to the cargo loss department with Landstar. You know, Mr. Gordillo needs to obtain information from corporate Landstar to give an update. And that's important, to give an update to its customer. Where are those emails? Where are those communications? Why is it that Landstar's agent believes that Landstar is just going to accept the cargo loss, forward this to cargo loss prevention? That's because Landstar has talked about this. They decided it. Hey, if we broker this stuff off when we've accepted as a motor carrier, then, you know, we'll pick up the tab if there's any cargo loss. I mean, this testimony alludes to that there is, in fact, discussions about that. And Landstar is going to want to say all of this is attorney-client and this is work product privilege. But right here in this email, she's trying to obtain information from corporate so she can update the client, right? And I've also requested not just emails, text messages, these types of communications, but board meeting minutes, because somebody up there on the ladder, at least above this agent, has discussed when companies like My Universe haul our loads, we're going to take a position that goes to the cargo loss department. I mean, she automatically did that. Now, here in this trial, they're saying they're not liable for anything because they're just a broker. Well, obviously, there was some discussions. Now, the reason this is not attorney-client privilege or work product privilege, first of all, I didn't request any communications with any attorneys. Second of all, to be work product privilege, yes, it has to be in anticipation of litigation, but the case law, specifically the case law that I have cited, says that litigation needs to be the primary purpose. For instance, I will direct the court to the In Re Farmers case. It says the investigation must actually be conducted for the purpose of preparing for litigation. An investigation is not conducted in anticipation of litigation if it's prepared for some other purpose. There's obviously been communications between Landstar Corporate and its agent regarding loads that were hauled by people not operating under Landstar's authority, just like we saw in Request for Protection 1, 2, and 3. And these emails were not, and these communications were not made in anticipation of litigation. She clearly says it right here. He's trying to obtain information from corporate to give an update, not so we can prepare for a lawsuit or any sort of purpose of litigation. So with Request for Reduction 1, 2, and 3, we believe that these should have already been produced, but they should be produced now, but prior to trial, because not only are they relevant to understand what Landstar's knowledge and notice of the potential liability is, but also this would also go to gross negligence, right? If they knew that they would be liable for this and they continue to do it, we could certainly make that argument. Now, Landstar in its response says that I'm asking for a legal conclusion. I didn't ask Landstar what it thought about about statutory employment, whether to make a ruling on it. I didn't ask them to make a ruling on whether they were liable or not. What I'm asking is, did they at least consider, do they at least have knowledge that they could be liable? So Landstar's contention that I'm asking for a legal conclusion, nothing in these requests for reduction 1, 2, or 3 seek a legal conclusion. And board meeting minutes, the last one I'll address, those are routine. Every business the size of Landstar will have board meeting minutes. So that's not for the purpose of litigation. That's for the purpose for the regular course of business. And so in that reason, they can't hide behind work product in regular board meeting minutes. I didn't ask them for meetings with their attorneys to discuss the strategy in this case. I asked for board meeting minutes because it is obvious that Landstar Corporate, especially the cargo loss department, was not only involved in this case, but they were probably involved in multiple instances where carriers not operating under their authority have gotten into incidents that Landstar has then potentially accepted liability for. To move on, Your Honor, I want to go briefly to the next discovery request. This is interrogatory number 1. It's along the same lines. Has Landstar ever discussed internally its potential liability for the below? And again, we see the same 3 things that we asked in request for reduction: motor carriers that are hauling their loads, not operating under their DOT authority, accepting loads as a motor carrier and brokering out loads, and then statutory employment. Again, I'm not asking them to give me a legal conclusion. I'm asking them to tell me what their knowledge of it is, and to use that to then say, look, Landstar had knowledge of this. They were aware. I'm not asking them to brief this for me, to tell me if this is a proper argument or not. I just want to know, was it discussed in these routine meetings that were in business? And then request for reduction number 4 is just, if you have discussed it, produce the documents to support that you have discussed it. Now, again, I think Landstar is going to want to say attorney-client privilege, work product privilege, but I want to point out, Your Honor, in each of these responses with their objections, Landstar isn't telling you they're withholding anything. That's the first step in the Texas rule procedure. If we want to claim privilege, we've got to let the party know we're withholding something for privilege, and then let the party know what the privilege is. All they're doing is telling us this is evading privilege. But are they withholding information? Is there information that is not privileged? We don't know that. So, Your Honor, I ask that you just overrule these objections because they are not compliant with Texas Rule of Civil Procedure. And then lastly, Your Honor, I'm trying to be conscious of the court's time. Two things that I wanted to ask. First, I asked, did you engage My Universe to haul the subject load through an internet-based load board, internet freight exchange platform, or other similar website? If so, please state the website that was used, the web address, and who posted it, and the dates it was posted and accepted, right? That's the question. Here is Landstar's answer. My Universe had been haul broker loads as a motor carrier relative to this subject load. Landstar would direct this inquiry to My Universe. Well, first of all, I'm asking you, did Landstar engage My Universe to haul the subject load? They didn't even answer that. They can't even tell me whether they engaged them or not. Second of all, they tell me to go to My Universe, but they would be equally available to this information as well. If not more, they're the ones that posted it on their load board. And they're the ones that went and sought My Universe to haul this load. So directing it to My Universe, I think, is a little bit disingenuous. They would have all of this information. And then again, produce all documents to support your answer to the above. And specifically, I want emails, written communications, or screenshots that relate to the engagement of My Universe for this subject load. And real quick, Your Honor, what I want to do is I want to show you, because we took the deposition of a representative for My Universe, and this is what he says. He says, once we book the load, we get a confirmation email. There we go. And then it goes on. What documents are those that confirm the load? It's just an email, or do they send you an actual document? We only get an email confirmation. And then we go down here, and the representative says, yes, I did get a confirmation email when asked about a confirmation email from Landstar. And then we go down here, and I ask him, let me show this to you. Is this the rate confirmation that you were talking about that you received when you accepted this load? Yes. So you have received this in email with this as an attachment? Yes, correct. I have never seen an email. All right. Landstar would have that email. They apparently sent the email. That was a sworn testimony. I have requested this email. This is incumbent of a whole bunch of other discovery requests where we've asked generally for communications regarding the transportation of this load and things like that. But I got really specific because I wanted to avoid any type of these boilerplate objections like what we are seeing here today. Now they're not saying, oh, well, that was too vague or whatever. Now they're saying, well, just go ask My Universe. We don't have it. Just go ask them. Well, they do have it. They sent the email. They have this in their possession. I know we're coming close to trial, but we need this. This information should have been produced 2 or 3 years ago. I've tried to ask it as narrowly as I can to get a proper response. I have not gotten a proper response, so that's why I'm before you, Your Honor. So with that, that is my motion to compel.
Thank you. Who is going to respond?
I will, Your Honor.
Go ahead.
Yes, Your Honor. The bulk of the motion addresses the requests related to Landstar's quote unquote potential liability under a quote unquote statutory employer doctrine. I mean, that is plainly a legal question that the court will be asked to decide. It involves the construction of statutes, as its name suggests. I mean, as a matter of law, there is no such statute upon, that creates any employment relationship between the driver and the employer in this case. Plaintiffs, are just relying upon inapplicable truth and leasing regulations that have nothing to do. But ultimately, that's a question directed for the court to analyze based off of legal precedents and its legal training. It's not something where you produce lay witness discussions on topics of potential cargo loss liability for cargo claims wholly unassociated with this personal injury case. The requests in this case fail on multiple levels. I've thought about ways to try to visualize and conceptualize this. I did it in a few slides. And so with the court's permission, I'll show those. And so what we see, Your Honor, is hopefully the slides are showing. But the first step in any of the analysis is the court has to look at, several hurdles that the request must come through in order to ultimately require us to respond to them. The first is relevance. The second is proportionality. And the third is they have to be reasonably tailored. And fourth, they have to seek non-privileged information on their face. And so when you go through each layer of this analysis, the requests fail. Starting with the first step. The requested discovery is not calculated to lead to any admissible evidence. It requests, communications to be resolved by experts of law, something for the counsel and the court to argue via legal briefings. To the extent any opinion were to be offered by a lay witness, based off of their untrained, analysis of legal questions, it'd be categorically inadmissible. Even if an expert was asked their opinion on the statutory employment doctrine, that would not be admissible. But certainly lay witness testimony is inadmissible on that basis. And so the Texas law is absolutely clear on that. You can't compel discovery on legal questions since that won't ultimately be admissible. And the Texas courts of appeals have specifically addressed this in the context of employment for workers' comp purposes, and they said you cannot request or compel discovery on legal terms of art such as employment. And so turning to the second step, your requests can't be unduly burdensome, and you have to pursue the discovery through the means that's least burdensome. And so in this case, where is the best source of analysis for the statutory employment doctrine? Legal precedent, court decisions, secondary legal authorities. Nowhere in the hierarchy of legal analysis is it, well, we consult untrained employees with no legal education or no legal experience at each party. I mean, if the tables were reversed and we were asking the plaintiffs, the court to compel the plaintiffs to give a deposition on their understanding of Gregory versus Chohan and how it impacts their ability to ultimately recover damages in this case, I mean, the plaintiffs would be jumping through the roof, and understandably so. I mean, there's no precedent at all to compel production of documents or requests for interrogatories related to potential liability under some state of the law. So that's step two. Turning to step three. The claims are grossly overbroad. There's no time limitation. There's no place limitation. There's no subject matter limitation. And there's no limitations on the parties. And so I think when you heard the plaintiff's counsel address this issue, he said, well, we're interested in cargo loss. Okay, well, which cargo loss claims? All of them throughout the entirety of Landstar's existence? We're supposed to produce written communications related to claims for cargo loss. This isn't a claim for cargo loss. It has no bearing on liability for personal injury claims in this case. Cargo loss implicates an entirely different statutory scheme in that it relates to the Carmack Amendment, which has its own unique regulatory structure. Separately, it also implicates things like indemnity obligations and contractual obligations that are unique to the specific parties in that case. And so what the analysis of a cargo loss claim may entail has absolutely no bearing on the tort liability principles in this case, assuming that were even a proper subject for discovery, and it's clearly not. And lastly, you get to the issue of privilege, Your Honor. All of the objectionable requests, or at least most of them, explicitly request communications concerning legal doctrines, that being statutory employment and the assessment of liability, potential liability based off them. Plaintiffs' counsel in their motion and today say, well, we didn't request attorney communications. There's absolutely no carve out for in-house counsel communications. There's also no carve out for representative communications used to facilitate the rendition of legal services, which qualifies as privileged communications under Rule 503. So on the face of the requests, Your Honor can see that they're seeking protected legal communications and work product analyzing claims in the context of a particular case. And so, I mean, to the extent the plaintiffs want to disclaim any request for communications with lawyers or anything that's derivative of communications with lawyers, well, then what are you left with? You're left with lay people with no experience in the law, pontificating about legal liability or potential legal liability without any basis whatsoever. I mean, that's clearly irrelevant, and it'd also clearly be inadmissible on these issues. And so the plaintiffs haven't established that any of the requested information falls within the scope of discovery. And so when you kind of parse what they're saying, I think it fails on a couple of levels. And the first one is this, just to kind of broaden back out to 50,000 foot. Clearly, if the plaintiffs wanted the legal analysis associated with the Landstar's potential liability in this case, that would be work product and attorney-client privilege. They realize they can't get that, so what do? They expand the request to all claims as if somehow that cures the problem as opposed to exacerbates it. It makes it worse. Instead of just asking for our legal analysis of the issues in this case, they expand it to every single cargo loss claim, every single personal injury claim, every single accident that has ever occurred involving third parties with whom the Landstar has contracted. I mean, it's so overbroad, it can't even be expressed in reasonable terms. Literally, we would have to produce communications for every single claim that was ever asserted against Landstar or one of its contracting carriers. Separately, it has no bearing on any issue in this case. The plaintiffs are mixing apples and oranges. They say, well, these communications may go to the issue of gross negligence. They have no bearing on the issue of gross negligence. Gross negligence liability only exists to the extent there's knowledge of the particular injury-producing risk that manifested on the day in question. And so that relates to the driver's negligence in this case that it caused this accident. It doesn't entail knowledge of a regulatory scheme that may impose, monetary damages for other losses. I mean, clearly every defendant knows that there's a tort system. If, somebody's negligent, they're responsible for it. That's not the basis for gross negligence. The basis for gross negligence is the specific tortious conduct in question. And so there's absolutely no relationship between the requested discovery in this case and any assertion of a gross negligence claim. I mean, the plaintiffs haven't cited any case in Texas history that has ever ordered production this broad addressing these legal issues. And as far as I'm concerned, or as far as I know, and I looked at this pretty extensively, no such case exists. Anything that has even come close to addressing these type of issues, either the trial court has put an end to it or the appellate courts have put an end to it. It literally is an unprecedented request that, as far as I can tell, has absolutely no support or precedent in Texas history. And so we would respectfully ask that their motion to compel be overruled for all of those reasons. And if Mr. Ancona has any additional arguments, I'll have him chime in as well. But I think this is a pretty clear-cut issue, Your Honor. And, especially as we're approaching trial, this is just something that needs to fall by the wayside.
You've heard it, counsel, Your Honor. You've heard enough.
Just, yeah, very briefly, Your Honor. Mr. Cathy gets up here and makes it seem like I can't ask any questions that would in turn ask anything about the law, right? Because again, I did not ask for legal briefs or their interpretation. I asked whether they discussed that they could potentially be liable under statutory employment or for carriers who are operating not under their authority. So, and Mr. Cathy gets up here and says, well, we can't ask anything like that. It's got to go to the case law. Well, just as an example, Your Honor, here's the discovery requests that we on the plaintiff side get from Landstar. Admit that you are aware prior to the accident that Texas law required children who occupied a recreational vehicle while moving must be seatbelted. So under Mr. Cathy's sort of argument.
I just point out that the plaintiffs objected to that.
Well, we did, but we didn't say it was a legal conclusion, right? And so then again, under this, I guess I should have said it's a legal conclusion because you can't even ask the questions, but these questions are asked every time. In the response to Landstar, that Landstar made, they acknowledged that legal contentions are proper. Okay, well, if that's proper, then do they contend that statutory employment is not applicable? Do they contend that they do not have liability? If so, did they discuss that? That's not privileged. Again, they haven't told us what's privileged, what's not privileged, whether they were withholding anything, whether they were not. But we do see from the deposition testimony that at least initially, they thought that they would be at least liable for some aspect of this crash, right? Because they were getting corporate involved in cargo loss. I'm not here trying to recover cargo loss for anyone, but that is relevant according to knowledge. And the last thing I'll say is that this goes directly to gross negligence because we have a negligent hiring claim. So if Landstar knew that they negligently hired fly-by-night motor carriers, and then most motor carriers were injuring people or killing people on the roadway, then we can certainly use that. So I think Mr. Cathy's argument that this does not go to gross negligence, I think that's also a little off base considering everything that we've alleged against Landstar. And that is all I have, Your Honor.
Okay. All right. And I guess just a question I had was in terms of something Mr. Cathy said about there being no limit in terms of, so for example, these are all internal documents and communications, requests for production 1, 2, and 3. They're not time limited. They're not limited in any way. Mr. Villanueva, can you tell me something about that? I mean, what are you?
They are not, but I think the court, Your Honor, if the time limitation is the key, of course, then the court's order could reflect that it can only go back to a certain period of time, and that can certainly be done. And I would be agreeable to, going back a year or a year from the incident, including the incident. And then another thing I would like to point out too, I'm sorry that I didn't, Your Honor, is that with the last request regarding those confirmation emails from my universe, which those are time limited, those are specifically for this case, Mr. Cathy did not even respond to those. Those are important too. I need those documents, but we can agree to limit it. If we want to limit it to, a year before, including the date of the incident, I think that would be reasonably appropriate.
Your Honor, respectfully, that doesn't cure the issue at all. I mean, Landstar brokers literally thousands or tens of, I don't even know the number, but it's a conceptually large number. I mean, tens of thousands, presumably a year. And so we're supposed to, over that course of year, analyze every single load and every single email with every employee in all 50 states. Well, that doesn't at all cure the issues associated with this. And, with respect to this negligent hiring claim, clearly the only negligent hiring that could potentially occur is with respect to this particular motor carrier at this particular time. But the plaintiffs have to acknowledge that they can't get our analysis with respect to this claim. And so the only one that's potentially relevant would be our analysis as to this claim. And clearly that's privileged and protected, in addition to it addressing a legal issue, which they can't explore. And so, to move beyond this case at, any measure, whether it's a year, you're clearly going overbroad and reaching into an obvious fishing expedition. I mean, the plaintiffs didn't request a year, and it's not this court's duty to tailor their requests that they'd never made. If they wanted a year, they should have asked for a year. And it's not this court's obligation to, now kind of, gerrymander their request into something that's cognizable.
Real briefly, Your Honor, Mr. Cathy wants to seem like I'm asking for every communication regarding brokering of loads, but the specific requests are communications involving potential liability for motor carriers that are operating under authority, statutory employment. That wouldn't be the normal routine course of business with every broker, right? So first of all, there probably needs to be something.
Hold on, Mr. But the requests don't say that, right? I mean, the requests are broader than that.
The requests request the communications regarding Landstar's potential liability, right? So if there's no communications regarding that potential liability, then I'm not asking for those. And, I would assume that if Landstar gave another motor carrier its load and it was delivered safely, there would need to be discussions about any potential liability. So this isn't every single load. This isn't the thousands of loads they do a day. This is just with regards to their potential liability.
Okay. Also in some of these responses, Mr. Cathy, I think if I'm not mistaken, it should be all of them. By virtue of the fact that these inquiries have already been responded to by Landstar, I mean, is that identifiable somewhere? I mean, it's part of each of those responses.
So I guess there's two separate buckets, Your Honor, with respect to the statutory employment doctrine bucket and all of, that potential liability bucket. I don't think any of those communications have been produced because they relate to, other claims that are wholly irrelevant. But with respect to those two last requests related to the message board in My Universe, those documents have been produced. As Mr. Villanueva's deposition testimony concluded, we produced the load confirmation sheets and other things like that associated with this particular load. And so I can defer to Mr. Rincon, who's more familiar with the discovery than myself. But that is what that's referring to, is we've produced the documents relevant to this particular transaction already.
Your Honor, just to address that, this load was coordinated through a independent sales agent, Little John, and the email exchange from expediters who put in the request for the service and the communication with them and Little John to coordinate it, locate driver capacity, broker the load to My Universe. Those emails have long ago been produced. They've been attached as exhibits to umpteen depositions. So that's what, in part, that would refer to.
But Your Honor, as I pointed out specifically in that deposition testimony, My Universe is saying they got emails from Landstar. I don't have any emails between My Universe and Landstar accepting the load or prior to the load. What I have emails is everybody talking about what happened after the crash occurred. I don't have anything saying, how did My Universe know where to pick it up? How did they know where it was going, those things? And if it's through documents, how do they get the documents? There has to be an email, some sort of text message. It didn't happen by carrier pigeon. So there needs to be some sort of paper trail for that. And we don't have that with us. So that's specifically what I'm asking. And again, I know that there's something there because they specifically said.
Katie, if you.
Oh, sorry, I did that prematurely. Yeah.
Go ahead, Mr. Villanueva.
Yeah, and I'm sorry, just from the email, from the testimony that they're there, it's obvious there's a specific email between My Universe and Landstar setting up the coordination of the shipment that we just don't have. And that's specifically what I'm asking for. And I've asked for it several times.
Your Honor, just to follow up on Mr. Rincon's point briefly. Little John is the Landstar agent who communicated. The emails for some of these individuals have Landstar in the name, but as you'll actually see from the extension, it's Little John Transportation Services, Inc. is the actual entity that was doing the communications. And so while it may say Aid and Landstar, Little John is actually the entity who was coordinating the communications. And those have all been produced. And as Mr. Rincon indicated, not only have they been produced early in the case, this is Bates number 59. There's literally been thousands of documents produced. These are the very first documents that were produced in this case. And as he indicated, they've been attached to multiple pleadings and documents. And so I don't think the one snippet of testimony where they're, saying there's a Landstar email is actually representative of the reality of the actual documents that have been produced.
Okay. All right. Okay. Anything else?
No, Your Honor, I believe this was also set for a pretrial conference. I didn't know if there was anything regarding our trial that you wanted.
We have a lot more to talk about, but we may have to put that to the docket call. So on the motion to compel, I am going to grant the motion to compel, overrule those objections with the understanding that the responses will be tailored or limited to, I don't even think I'm going to go a year out, 6 months out, and obviously would not include any attorney work product or attorney-client, any privileged documentation. So that is going to be the order on the motion to compel.
And just to be clear, Your Honor, what 6-month period is that? Is that before the accident, at the time of contracting, now?
The date of contracting, I think that would be the more appropriate date.
Date of contracting between whom, Your Honor?
Between Landstar and
My Universe?
My Universe. You threw out Little John, but Landstar and My Universe. Yes. Mr. Villanueva, if you would like to send over an order reflecting same, if we need to discuss this any further at the docket call, we will. I want to look at our scheduling for the docket. I know we'll have a lot to talk about. 10 a.m.
Your Honor, just to, because I'm preparing the order, 6 months from the date of incident, or?
No, the date that Landstar and My Universe agree on the load.
Okay.
That rudimentarily clear. On the docket call, we're going to have that instead of 10 a.m. We're going to have that at 9 a.m. on July 16th.
And Your Honor, do you have any sense for how much time you budgeted for the docket call?
Well, I don't. I mean, I would say an hour, but I feel like there's still a lot of moving parts. So I don't want to. I don't know that 9 o'clock is enough. Frankly, I almost feel like giving you all a whole day, but not a whole day, but a chunk of a day. But we'll start at 9 o'clock on Wednesday. Please alert the court if you have what you intend to cover. I mean, for me, docket call, it's kind of just wrapping up or getting an understanding what things are agreed to, how we're going to proceed, really some of the logistical stuff. But if we're talking substantive things, I need to have a little more heads up so that I can plan accordingly. Yeah. If anyone has a sense of that right now, I'd love to hear it.
Yeah, both sides have filed a series of substantive motions. And I believe what we can do is to make sure, Your Honor, we have filed those, both sides. Your Honor has copies, if to the extent you need hard copies, to get that to you.
Let me ask, counsel, would you, because there are so many moving parts, I can make an additional day available for scheduling matters. And frankly, I just assume we kind of maybe do that in person for those who are able to. I can make Monday available either morning or afternoon, I think. If not, let me see if I can do something on Wednesday. Give me 1 second. No, I can't do Wednesday, but I certainly can do Monday.
On Monday, July
15th, 14th.
14th. Okay, at what time, Your Honor?
Well, I say 9 a.m. It can be 9 a.m. It can be 1:30.
Some counsel may be flying in from out of town, so I think 1:30 would be preferable.
Your Honor, I, along with Mr. Lyles, who is here, we are set for an all-day mediation on Monday. But if you give us a chance to confer, we may be able to make things work. But also, I believe if we conferred with Landstar's counsel, we could narrow down what we actually want heard. I'm not sure if every motion that's pending now will need to be heard.
So just looking at the court's calendar, yeah, I was anticipating that we would have some travel and scheduling issues. You know, I could probably move that to, for whatever is left, the 17th at 1:30. So
Sure,
we do have
Judge.
a docket call, but I have a criminal docket going on, but they don't need me so much on that afternoon, so I could see you all in person on the 17th at 1:30.
Okay, Your Honor, yeah, that, so 17th at 1:30, and we won't be coming in on Monday.
Correct.
Okay, and we'll absolutely confer like we've been doing
Right.
with counsel.
Give me an update on docket call, what we're really gonna knock out on Thursday, unless you magically make everything go away and I don't see you until jury selection.
Your Honor, jury sheets, do you have any sense for when those are coming up?
I feel like they come out later than they used to, so unfortunately, no, we should have them by Wednesday. But you know,
Do they come out with a seating chart that tells us?
seating chart, and then get you the jury sheets. The seating chart will have the names.
And then finally, I don't know to what extent we'll be using AV for the commissioner's court, but same thing, should we go and make sure everything works there?
Whenever you're planning to do it for the court, I would run by commissioners and just double check Mr. Nunez to make sure that commissioners doesn't have it reserved for some meeting or anything like that, so we can give you all a heads up. They've been doing a lot of special meetings lately.
Okay.
And we are confirmed for commissioners on Friday, right, Mr. Nunez?
Yes, ma'am.
Okay. Yeah. I don't think commissioners is too complicated, but I know we've had some changes in our AV here, so I know Mr. Nunez was giving you some guidance on that.
Is
Okay.
the veneer panel, I believe it's 90? Is that which?
Oh, I think we're at like 120. So, yeah. So if what you're telling me is, Judge, we really don't want 120, I can knock some off, but, you know, it's, in my criminal cases, you know, we'll have 100, 240 and barely make a panel with 2 alternates. Jury with 2 alternates, but y'all are in a criminal case. Might be a little different. So
Yeah.
you let me know if you want me to cut down that panel. I'm happy to do it. 120 is manageable in commissioners. It might be excessive, but it's manageable. I don't go any bigger than that because then it becomes a little difficult.
Your Honor, I think it probably would be appropriate only because it's summertime, people are on vacation, and when the jury may hear how long this proceeding may last, even if it's a week and a half, 2 weeks.
We're gonna run out of people. I know.
Yeah, I think you're gonna get a lot of hardship approaches.
Okay. Yeah, we'll keep it as is. I'm good with 120. All right. What else?
And Judge, if I may, Sebastian Nunez here on behalf of Defendant RV Share. Last hearing, you had granted Defendant RV Share's motion for summary judgment, and I think I'm really just here in an abundance of precaution. There is still a cross claim for contribution from Mr. Rincon and his client that we have been in contact. I believe Sean White in our office has been in contact with Mr. Rincon about getting it dismissed. We're kind of in the position where it may be a little bit too late for us to file something since we're already approaching the docket call, but we're just kind of just wanted to update the court that we're hoping to see if Mr. Rincon would kindly just dismiss the contribution claim. But we'll
Yeah, I am not the legal scholar to ask on this, but my understanding is that we asserted a common law claim for contribution under, well, Texas common law, and I think Chapter 33 of the Civil Practice Remedies Code, statutory claim. And upon the dismissal by Your Honor of Mr. Sebastian's Nunez's client, I think our cross claim is extinguished as a matter of law. If Mr. Cathy can confirm my understanding, but I would think that's become moot. Mr. Cathy, am I right on that?
I think that's correct. I think, yeah, we had discussed that.
Yeah, and whenever, yeah, I don't like to hypothecate on the law because that's usually treacherous ground, but that's it.
Judge, to be honest, this is the first time I'm in this position where, you know, our motion for summary judgment gets granted, but there's still a cross claim for contribution. So it was a unique position where I wasn't sure if we needed to file something just to make sure, you know, we were coordinating with Mr. Ricon's office, but I guess based off of that discussion, we'll just kind of, you know, leave it at that, Judge, if it's okay with the court.
You can leave it at that. I think I would be more comfortable if you all somehow memorialize that in some agreed to document that we could have on file.
No
And
problem.
leave that to you, attorneys to figure out what that's going to say. And
No
if you
problem, Judge.
file it, but I would think that'd be the better way to go about it. Thank you, Mr. Nunez, for bringing that up. What else?
Thank you.
Anything else?
No, Your Honor, not at this time.
All right, gentlemen. Well, it's coming. We'll see you next week. Again, yes, the docket call, I know Ms. Hernandez is out right now, but there were some things that you all referenced today that would just say if you can give me a little bit of a heads up. I know our docket call may not be so intense next week, but certainly if we have anything for Thursday, so we can be on track. And I know I have still some work to do from today, so I'll make sure and do that. Anything else?
That's it, Your Honor. Hope you have a glorious afternoon.
Same to you. Y'all take care. We'll see you next time. I do want to give Walter a little bit of a break so we can get off of YouTube now. And I know we have a bunch